From the very first moment, the officer sets the tone, not with professionalism, but with pressure. He presents a false ultimatum. Give me your details or I can arrest you. It sounds authoritative. It sounds decisive. But legally, it doesn't hold up. Under Pace Code G, the necessity criteria within the Police and Criminal Evidence Act 1984, an arrest must not simply be possible, it must be necessary. That distinction matters. In England and Wales, you are not legally required to provide your name and address to police unless you are being reported for a specific offense, are under arrest, or are involved in certain road traffic matters. Outside of those circumstances, silence is not obstruction, it is a right. The officer references a potential public order offense. But potential is not the legal threshold. The standard is reasonable suspicion, an objective evidence-based belief that an offense has occurred or is occurring. Without that, the power to arrest does not lawfully engage. When an officer threatens arrest to compel compliance, without meeting the necessity and suspicion standards, it shifts from lawful authority to coercive pressure. And that is where due process begins to unravel.
In this interaction, we witness an example of police overreach and legal confusion. The encounter begins with officers attempting to coerce identification from the auditor by presenting a false choice between providing details or facing immediate arrest. Throughout the video, you will see the officers struggle to justify their actions, resorting to inventing a power to detain for questioning, and in a critical error, attempting to apply Section 19 of PACE, a power reserved for premises, to seize equipment on a public street.
Details or I can arrest you.
Yeah.
So that.
What's the details? Can I have your name and address? Name and number, officer.
Can you grab my phone so that I can?
You've just seen us outside the police station.
Can you identify yourself,
right,
please?
Can I explain why I've stopped?
No. Answer my colleague's questions. Thank you.
Identify yourself, please.
A person who was entering the property said that there's potential public order offences that have been reported. Therefore, I can require your details so that can be investigated.
No, yeah.
I'd like to do that rather than arrest you so that we can deal with it now.
No,
so let me just confirm.
Can you identify yourself, please?
You've not done that so far. Are you a constable or are you an impression?
I am.
That constitutes an offence.
11733.
Sorry?
11733.
Then comes another critical moment. The officer asserts that he has the power to detain you, to investigate. That statement should immediately raise concerns. In the UK, police do not possess a general power to detain someone simply to ask questions. There is no blanket authority to hold a person in place while officers figure things out. What often happens in these encounters is what's informally known as an invitation to stay, a request for cooperation. But unless a specific legal power is being exercised, that request remains exactly that, voluntary. Lawful detention on the street must be grounded in a clearly defined statutory power. For example, Section 1 of the Police and Criminal Evidence Act 1984, PACE, permits stop and search under specific conditions, and Section 23 of the Misuse of Drugs Act 1971 provides similar authority in drug-related contexts. Outside of those frameworks, or absent a lawful arrest supported by reasonable suspicion and necessity, you are free to leave. An officer cannot detain you simply to fish for details based on a vague or hearsay allegation. That is not investigation. It is improvisation. And when an officer attempts to manufacture a power of detention that does not legally exist, it undermines both procedural safeguards and public trust. Authority in policing is not defined by confidence or tone. It is defined by law. Without a lawful power engaged, there is no detention.
173. On police. Can you have my number? Thank you. Thank you. So at the moment I'm going to talk to this officer here because he's the one who's approached us at the moment.
Possible public order offence.
For what? For
I'm
standing
just trying
outside
to-
the gate? No, I don't think so.
No, just due to an interaction you had with them. That's the report I've got from them.
What interaction?
You also get to report and tell me what you want. So
We don't want to
that's
say
fair
nothing,
enough.
thank you.
There you go. If you don't want to
No
say anything,
comment.
but they did want to say something. So
Well,
unfortunately, when a crime is
It's not a
reported,
crime.
that
Public
gives me
order is not a
powers
crime.
to A, stop and detain you, to deal with that crime, and if required, arrest you.
Yeah.
My colleague now is just taking those details.
That's a load of crap, I think.
So once I know more about the report, I'll be able to tell you more. However, until then, I'm going to take some details.
No, thank you. Not until we know more details, at least.
You've been threatening people, you've been intimidating people to come in by putting...
As the second officer steps into the fray, the focus shifts from law to emotion. He argues that people feel intimidated. But here's the crucial point. Feeling intimidated is not, in itself, a criminal offense. Under Section 5 of the Public Order Act 1986, the legal threshold is clear. There must be threatening or abusive words or behavior. Not mere discomfort, not subjective unease, and certainly not the simple act of filming from a public place. Recording in public without more does not meet that statutory standard, no matter how it makes someone feel. Context matters. So does precedent. In Director of Public Prosecutions v. Oram, 1989, the courts made it clear that police officers are expected to display a greater degree of restraint and resilience than the average member of the public. In other words, officers are held to a higher tolerance for speech and conduct encountered in the course of their duties. The badge comes with thicker skin. When enforcement drifts from objective legal criteria to subjective emotional reactions, the rule of law begins to blur. The role of police is not to regulate feelings, it is to apply statute. And if the statutory elements are not satisfied, there is no offense, no matter how strongly someone claims to feel intimidated.
That's a lie. They felt intimidated by it.
Well,
They don't want to, they didn't ask for it.
Are you the feeling police then, are you?
The feelings police.
The feeling, yeah, because they feel intimidated, you have to
People
deal
feel
with it.
intimidated and threatened by it, and they don't like it.
Well, that's their problem, not mine.
If
or
some people
yours.
intimidated you, you want us to investigate
No,
wouldn't you?
no, because I've already been through that one, and they didn't do anything about it. Right,
That's
so
you. But other people, if they feel
no,
threatened
the
or
police didn't do
intimidated,
anything about it.
they'd want us to speak to them on that.
Because
That's
it's the
what we're doing.
police, you're doing something about it. And we haven't committed a crime. There's no law against us filming outside.
No, I'm not saying there's law against you filming.
So we haven't committed any crime.
I don't mind you filming, crack on.
and we're filming from a distance, and there's evidence of that
So
on my camera, his
their
camera, and
feelings
cameras
don't come
like
into
that.
it. Their feelings don't come into it
Why not?
because they're police. You have
says they're
you have
police?
a higher tolerance.
Who says they're police?
Right? They're control staff, whatever.
Who says they're
They
police?
work for the police.
Do you know who they
This is the defining moment of the entire encounter. Officer ARV6 invokes Section 19 of the Police and Criminal Evidence Act 1984, claiming it gives him the authority to seize the phone. But this is a profound misapplication of the law. Section 19 does grant a general power of seizure. However, it applies specifically to a constable who is lawfully on premises. The power is triggered when an officer is already inside a property under a lawful authority, such as a warrant, consent, or another statutory power, and discovers evidence that meets the criteria for seizure. It does not create a freestanding power to confiscate property from a person standing on a public street during a stop. The public highway is not premises, for the purposes of this section in the way the officer suggests. Attempting to stretch a premises-based seizure power into a street encounter demonstrates a fundamental misunderstanding of statutory limits. If an officer were to take a phone under those circumstances without a lawful power engaged, the act could potentially amount to trespass to goods, and in extreme cases, even unlawful interference with property. Police authority is not elastic. It does not expand to fill gaps in justification. When statutory powers are cited incorrectly, it is not a minor technical slip. It strikes at the heart of lawful policing. Powers must be exercised precisely as Parliament intended. Anything less risks turning enforcement into overreach.
Are you going up the
Control staff or the
civilians
police.
or
Some of
whatever
them were
you
police.
do?
Some of them were police
How do you know?
because they showed their ID badge.
They might have been the police paper. They could be a civilian member of staff.
Well,
They don't have to mind
they still have a high tolerance of
How do you know that?
because I do. You
Because
have a,
we do.
if I swear, if I keep swearing and swearing, you can't do me for it because you have a higher tolerance.
Yes, we can. Under Section 5 of the Public Order Act,
You have a higher tolerance
can.
if I'm swearing at you than I was
You don't
swearing
know
at
who
others.
you're talking to there, do you?
Okay.
I wasn't talking to
You
nobody.
don't know who they are.
I'm talking to nobody.
You're putting the cameras in front of their faces. You don't know who they are.
That's a
The
total lie.
lady spoke to me, so in interaction I filmed it, which I got my allowed to do.
Yeah.
So there is no crime here whatsoever.
if they're intimidated by it, then
Okay, but under section 19 of the Police and Criminal Evidence Act, when a crime is reported, and I can see you...
The officer eventually concedes that his actions are based on a third-party report claiming the auditors were aggressive. And yes, police are entitled to investigate reports from members of the public. But investigation is not blind acceptance. It requires an objective assessment of the facts as they exist in the present moment. What do we actually see? Calm behavior. No threats. No violence. No conduct that objectively meets the elements of a criminal offense. Instead of identifying clear evidence of wrongdoing, the officer pivots to threatening seizure of the phone, ostensibly to check the footage. But that is not targeted investigation. It is a fishing expedition. Rather than gathering independent evidence to establish reasonable suspicion, he attempts to compel the very person accused to hand over material in order to disprove the allegation. That flips the burden of proof on its head. In the UK legal system, it is the responsibility of the state to prove that a crime has occurred, not the responsibility of a citizen to prove that it has not. Demanding access to private property in order to search for justification after the fact undermines that fundamental principle. Standing firm in that moment is not defiance. It is the lawful assertion of privacy and property rights. Surrendering a personal device without a clear and lawful power engaged would mean relinquishing protections that exist precisely to prevent speculative, evidence-seeking overreach. Due process does not bend to accusation. It demands proof.
Already, I can take and seize any articles that may provide evidence of an offence.
And then I'll sue you.
So
And me.
as I'm saying, you're saying you've recorded it, therefore that almost makes, I can 100% guarantee there's evidence on those machines.
But we didn't do anything.
Okay, so let us just have a chat.
Exactly.
Let's see what was going to happen, okay? And we'll get to the bottom of it. We're not being argumentative with you. We're telling you, we were trying to leave. I didn't have an issue.
We were trying to leave and you stopped us.
And I didn't have an issue. However, prior to me leaving,
my issue.
someone reported and told us via the radio that they said that you were aggressive towards them.
Rubbish. That's lie.
Hang on.
Go and tell them the lie and
Does
do
it-
them for lying to the police.
Hang
then.
on.
No, you said they said we.
Sorry, intimidated. Aggressive and intimidated, okay?
Well, wasn't
However,
aggressive,
listen,
that's a lie.
Listen,
And
you're
you got-
interrupting me now.
Then comes a telling shift in language. I feel you are being aggressive. Notice the wording. Not, you are threatening. Not, you are committing an offense. But I feel. That distinction matters. In UK law, a breach of the peace requires either actual violence or a genuine, imminent threat of violence. It is not triggered by discomfort, irritation, or an officer's subjective perception of tone. Asserting your legal rights, declining to answer questions, and filming police in a public place are not acts of aggression. They are lawful exercises of civil liberty. What we see here is a subtle but common escalation tactic. Reframing non-compliance as hostility. By labeling calm resistance as aggressive, the officer attempts to manufacture the emotional groundwork for enforcement action. It shifts the narrative from legal rights to perceived attitude. But that strategy only works if the subject reacts. The auditor's composure is decisive. He remains calm. He does not shout. He does not threaten. He does not advance. And without conduct that objectively signals imminent violence, the legal foundation for a breach of the peace simply is not there. In high-pressure encounters, emotion is often used as leverage. But the law does not operate on feelings. It operates on facts. And calm, controlled assertion of rights does not transform into aggression simply because it is inconvenient.
I then get to come and ask you and say, that's what's been said. You get your chance to tell me.
Well, that's a lie.
Okay.
We
Nasty
didn't
character,
do.
mate, him.
That's a lie.
But when a criminal offence is being alleged, and one has, we are entitled to do that.
Look at that ugly face he's got. Do you feel offended by that? You shouldn't do. Just let them get on with what they've got to do.
So why didn't you stop outside the gate instead of stopping there?
That'd be more
Because we
appropriate.
didn't get told until we got there. But thank you very much for...
I bet that's a bit of a porky pie. Literally porky.
So can I report a crime?
If it's genuine,
Yeah.
If it's genuine.
I feel intimidated. I feel that you're being aggressive, so I'd like to report that.
okay.
That's not reporting a crime, that's reporting a complaint.
That's a crime. You just said it was a crime.
At this stage, the encounter stalls. The momentum shifts. The officers have reached an uncomfortable realization. The auditors understand the legal boundaries in play. There is no name, no address, no phone in police possession, no clear offense established. The leverage they anticipated simply isn't there. This moment underscores the strategic power of restraint, of saying little, volunteering nothing, and standing firm within your rights. Silence, when lawful, is not obstruction. It is discipline. Had the auditors yielded and handed over identification without a lawful requirement, the likely outcome may have been a face-saving measure, a community resolution, a warning, some minor disposal designed to justify the escalation. Not because the evidence demanded it, but because authority had already been asserted. By refusing to concede ground without a statutory basis, the auditors narrowed the officers' options to two lawful paths. Either articulate genuine grounds and risk the consequences of an unlawful arrest, or disengage. It becomes a quiet standoff. Not dramatic, not chaotic, but decisive. And in that standoff, the determining factor is not confidence, not volume, not uniform. It is legality. When the law is correctly understood and calmly asserted, it shifts the balance of power entirely.
You saw us down in outside the station when we was out there, but you didn't want to stop us because it's raining. You got in your little car, you left, let us do what we wanted to do, go home, or go at the next location, and you got in your car, you thought you'd be Clifford now to waste our time, but it ain't really waste our time, is it?
I appreciate your opinion.
That's my opinion.
In the closing moments, the officer makes one final attempt. As the street sweeper drowns out the conversation, he circles back to where this began. Will you provide me with your details? It's a reset, a return to the opening demand. Not because new evidence has emerged, but because no lawful leverage has materialized. This repetition is revealing. When an officer truly satisfies the necessity criteria for arrest under Pace Code G, particularly on the ground that a name and address cannot be ascertained, the process is clear. They do not repeatedly request compliance in hope. They act. Arrest follows. The fact that the officer is still asking, still hoping for voluntary surrender of details, strongly suggests the threshold for lawful arrest has not been met. The earlier ultimatum, details or arrest, now appears less like lawful authority and more like tactical pressure. He is not escalating because he cannot. The legal foundation simply isn't there. And that is the quiet conclusion of the encounter. When necessity cannot be articulated, enforcement cannot proceed. The bluff dissolves, not with drama, but with repetition.
Okay, again, so as I said, and typically it's now going to get noisier.
Yeah, fair.
As I said, crime was alleged. I'm going to ask you again, will you provide me with your details? I'll apologise, I couldn't hear your answer due to the loudness of that machine.
No problem. Yeah, no thank you.
You said no? No. I still can't hear you.
No.
No, thank you.
We haven't committed a crime.
Exactly.
Well, unfortunately, you're entitled to your opinion, but when one is alleged, I'm entitled to mine.
As the officers finally drive away, the auditor captures the license plate, a simple but smart step. Documenting identifying details is best practice if you intend to file a complaint with professional standards, particularly where there has been an attempted misuse of Section 19 of the Police and Criminal Evidence Act 1984 on a public street. And when we step back, the pattern becomes clear. No clearly articulated offense. An effort to prioritize subjective feelings over statutory thresholds. And a troubling misunderstanding of seizure powers that apply only when an officer is lawfully on premises, not during a routine street encounter. This interaction stands as a case study in why public scrutiny matters. Accountability is not anti-police. It is pro-law. When statutory powers are misapplied, whether through misunderstanding or overconfidence, it is the responsibility of informed citizens to challenge that misuse calmly and lawfully. Auditing, at its core, is not about confrontation. It is about transparency. It tests whether authority aligns with legislation. And in this instance, the test exposed critical gaps. Because in a system governed by the rule of law, power must always be exercised with precision, or not at all.
At the police station, it's over there. Right, and we left there. We was walking by. Now this car's just approached us. It's obviously a police vehicle, and it's the armed police outside Cold Harbour
I think I've met before somewhere else.
police station.
On another occasion, and they've got intentions to go to another location after this.
Yeah, I'm going back home. The next location for me, bed.
Okay, there'll be a report made and we've got your descriptions, okay?
Yeah.
Lovely.
We've done is on camera as well.
You felt you'd done some work today for the public. Got my description, our descriptions. No one's offended at police station.
Enjoy your days.
Enjoy your day.
You too.
Thank you very much for the photography. It's not crime in public. I'll make sure they remember that in a minute. Get their fucking numplate after that business. How dare they even chase, right,